when you first approached us, you had an ideal goal of reducing the length of the agreement to 2 pages. But we were really unwilling to expose IX to the level of liability that would cause. We really think that reducing it to 2 pages would really force us to get rid of some terms that we find are essential for protecting liability for IX.
Excuse me, could you give me an example of what some of those things might be?
Some of the liabilities?
Yeah, so you said that you found it difficult to drill it down to 2 pages because you didn't want IX to be exposed to some legal implications.
Sure. So, for example, maybe under like the general terms or some of the warranties that we make, I think that upon initial read, it seems as if those might be superfluous to the actual essence of the contract. However, from a legal standpoint, those are things that you would want in there. Those actually are essential because they protect you in the case of future liability or future litigation. So it's more of a future problem versus a now problem.
Can they exist somewhere else other than the contract and still protect IX?
Some things, which we were about to speak about in a second, some of them are implicit in the law. Some of those might be statutory and could be eliminated from the contract. In California, for example, good faith in a contract is read into a contract and wouldn't need to be explicitly stated. So we did delete some things from the contract that would be statutorily read into the contract itself.
Is the request for a 2-page document unreasonable?
We can deal with that one.
Yeah.
We think it is, yes. We don't think that we can provide you adequate protection from liabilities in a 2-page document. And like Andrew was just saying, if we hand another legal department a 2-page contract for complicated, sophisticated companies, they're not going to, it's going to take longer because then they're going to have more questions, more concerns, and they're going to want to make their own changes. They're going to have it back and forth.
Yes, if you'll refer to the memorandum recap page, and on the back, we made a liability of options scale to try to put into context just how risky a 2-page shortened contract is. So I don't know if that, we just did that to simplify the process, but.
No, I'm a visual person, so that's good.
And then just drawing conclusion, also if the document is shortened, then you have ambiguities. And if there's ambiguities, like you said, then the other legal department would want to question every single thing. Well, what happens here, and they probably want to add that in there. Because legal does not like ambiguities, because then that leads to litigation later on down the line.
And I think another thing that we focused on, and especially since our group is the only group on the table right now that's offering one complete legally binding document, that it's not so much the length of the document perhaps, but also how readable the document is. And of course we want to take out sections that are irrelevant, and most of the groups have addressed putting a definition section toward the back and taking out terms that we don't absolutely need to have in there. But at some point, and this is really our idea going forward, was that you could have the document maybe a little bit longer than 2 pages. We could probably, you want to be protected, but as long as you have a document that has clear headings, a table of contents that reads like a user manual, that is very easy to navigate through, that the CIO should be able to have the same exact contract in one document that's given to legal. And then one other thing that I wanted to, 2 other quick points that I wanted to make as sort of a follow-up to that was there are some other reasons that we have in the table for not having extra floating documents floating around as sort of the other option, of having the shorter contract and then other legal documents floating around, or a longer contract that only goes to legal, and you make up for that with other floating documents. Regardless of whether you have an integration clause or something that says that the extra floating documents are not legally binding, the general idea, the general principle from a lawyer's perspective is that courts interpret ambiguous language against the drafter. It is an extra liability, and I don't think there's any way to draft 2 separate documents in a way where you can be sure that you're not going to have some type of ambiguity that comes up. It seems like needlessly opening up yourself to extra liabilities. And the other thing is, I'm just thinking, what type of confidence will it instill in your clients if you go, here, CIO, our contract is so difficult to understand, because you're already proposing something kind of out there. Let's face it, IX is kind of like, listen, this is a very front-running, this is a new type of idea that we're trying to sell. But the moment you say to me, you know, here's CIO, here's a summary, or here's some extra documents to explain our contract, it's so difficult that you're not gonna be able to understand it without this, you know, that to me undermines a sense of confidence.